Go ahead and call this special meeting, January 24th, 2022 of the Georgia Government Transparency Campaign Finance Commission meeting to order. On the agenda today, we've got two cases where we've been asked to review initial decisions from the Office of State Administrative Hearings. Procedurally, we can accept, reject, or modify the decisions that have been rendered by the administrative law judge before OSA. We're going to have oral argument, again, just so that we're all on the same page. I know that Mr. Chalmers is here for these cases as well, but we're going to have oral argument. We're going to limit it under the regs to 20 minutes per case, for each argument, for each counsel. We'll take the cases up individually and separately. Once as I understand it under the regs, once the review hearing is concluded, the commission shall then deliberate in open session and vote in open session as to whether to accept the decision of the ALJ, to reject the decision of the ALJ, or to modify the decision of the ALJ. So I'm going to go ahead and call the first case, which is 2009-0007 in the matter of John W. Oxendine. The movement in this instance would be the Attorney General's office. So, Ms. Young, you can proceed.
Mr. Chairman,
yes.
One quick, just a reminder that Mr. Thompson, or Commissioner Thompson, recused himself from this case back at the preliminary hearing.
Okay. I should have asked for an appearance. I apologize, Mr. Chalmers. I'd already spoken with you, so.
No, sir. After I already misspelled your name, I think.
I ask a question on my end. Is there somebody that will be behind me and maybe wave at me?
Well, what you want a 2-minute marker?
2 minutes. Thank you all for being here. All of us. This already noted. I don't want to repeat anything. Case. Otherwise, it becomes final by operation of law. We felt that both of these cases were but also for the determine that the decisions are correct. Process that there will be a vote at the end. The actual background of this case was that the respondent he had been the insurance commissioner beginning in 1994 and had been reelected. He raised millions of dollars in campaign contributions. In 2009, the commission alleged that Oxendine had accepted campaign contributions that complaints alleged that 10 tied by connections to one and the same And when you'll see PACs and quotes throughout this PowerPoint, because they call PAC is in your name, but whether it's a political type of entity is a key question in the case. The complaint alleged that each of these PACs had received contributions, $2,000 from State Mutual Insurance Company, $1,000 from Admiral Life Insurance Company, which were regulated entities that were prohibited from donating to the insurance commissioner directly. Anderson also made some allegations that Watkins, who was the PACs, and a man named Delos Yancey, or D, had been, these are his words, connected legally as commissioner with seats at the Braves game. Mr. Oxenine, his counsel responded saying that the commission, as it is required to do by law, began to investigate the filed by Oxenine, showed a series of contributions from these identical contributions on the same dates. On 508, you had 10 contributions in the amount of $2,000 each, and those were designated to the primary campaign. And then on 12/31/08, you had each $5,000 checks to Mr. Oxenine, and they were broken down on his CCDRs and allocating one, splitting one to kind of get within that contributions at the time, 1,100. Collection. So the commission obtained records from the Alabama Secretary. Alabama, unlike Georgia, registers their PACs differently. Campaign Finance or Ethics Commission. Ultimately ended up leading to what we They all had the same address, they all had the same phone number, they all had the same person and the same creditor. The commission then obtained from the 10 PACs, all from Al-America Bank. All had a P.O. box address of 70 Highland Avenue in Birmingham. Watkins law firm, and he was the signatory for each of the checks on that account. All 10 of those PACs issued identical living. Records, and then also some interviews that had been done by commissions. That first hearing was held in 2009, and at that time the commission did consider Proxendine, but expressed curiosity about what's going on with acts, and basically directed and see what it can find out about it. Multiple court proceedings took place in that case. The Court of Appeals eventually entered an order that basically staffing concerns that at that time that could investigate it, and that ended up prejudice of the case against the donors. However, left the case against Oxendine still alive. So after counsel filed a number of motions, partially granting and partially denying those motions.
And I appreciate the factual background, the procedural history and all that, but we've already run through maybe half of the time, and so I want to make sure that
I want to make sure
that we get to the nuts and the bolts of this. I have a question just sort of right off the bat.
Sure.
In the statement of matters asserted at OSA, was the allegation that 21541A was violated because these were affiliated committees, or was the allegation in the statement of matter asserted that 21541A was violated because these multiple entities that you guys have classified as PACs constituted one political committee within the terms of that provision of the statute?
We did reference the affiliated committees. That would be appropriate for an evidence for a fact finder to, political action committees. Was it a subterfuge? Was it
Maybe we're not connecting, maybe I'm not articulating my question appropriately enough, but when we had our preliminary hearing on this, there was a lot of discussion about whether, and Mr. Lane argued that the 10 entities, because of the definition that exists in 21540, the definition of political committee, it's any other group of persons or entities which makes a contribution. We had a lot of conversation about that and with Mr. Chalmers as well. What my question is in the statement of matters asserted that went to OSA, was it alleged that those 10 entities were a single political committee, or it was alleged in there?
Yes.
Right? And was that argument made to OSA?
Yes, and also alternatively, so that the preliminary hearing and made a to the ALJ. The ALJ just reached.
That's the issue of whether the 10 entities constituted a political committee within the confines of 21541A. Did the ALJ address that?
Not expressly in written.
And that's why I'm just trying to make sure that that was an argument that was raised, on your side of the case, in response to Mr. Chalmers' motion to dismiss, that there's an argument and potentially a fact question that remains as to whether these 10 entities constitute a single political committee so that it falls within the definition of 21-541A.
Yes.
All right.
So pled some other things in the alternative, but that was Jay's opinion was basically that it didn't matter, that no matter did not control the 10 separately filed political committees that why we're really here today. I'll go ahead and so because the ALJ has not under the rules of construction, and unambiguous, there's nothing for the commission to do other than apply it. But if the commission believes we don't have any documented. Look at how the law changed and before 2000, 41A the donor, anybody other than the donor, it applied only. Also, the legislature came in and put in of 41A that we now see, adding corporations and making it clear that they wanted of the act and to increase, to make sure that both added 41C. I think from just context cues, from looking at how these changes were made, it's a figure. The legislature thought they had cast a bit wide of a dragnet with 41A and wanted to apply business entities So it seems to us that the 2005 amendment hold the recipient responsible for donating. There is a provision for affiliated reference from 41, but it does tell us
You can reserve that if you want to. I didn't mention that before. Do you want to reserve that?
I'll just conclude with one
Okay.
other thing. The main thing to look at when you're trying to decide how a statute should be interpreted is what wrong is this statute trying to address. The Ethics and Government Act's policy is really clear that they want to avoid apparent corruption, Buckley versus Mullen. Are, and what the courts, what the posture that, in fact, it really goes against that because it, you know, certainly says it. That the commission consider all of that, whether through 1A or 1C.
Thank you, Michelle. Mr. Chalmers, you going to be the one arguing?
Mr. Chairman, we're actually going to split the argument, if you don't mind. I will do about 75% of it. Actually, about 50% of it, Mr.
Raise at the end, so it'll take about a minute or two.
Great. That's it.
Thank you, sir.
Do you mind if I interrupt you right out of the bat?
No, sir.
Right off the bat?
Yes, sir.
You got the time going? Okay. I want to ask you the same thing that I just asked Michelle.
Right.
Our preliminary hearing, and there was a lot of discussion about the definition of political committee. And
Correct.
I'm on the position that there was, you know, there were reasonable grounds to believe that the 10 individual entities that made these donations could constitute one political committee under the definition of political committee that's in the Act, and therefore fall under the provision of 41A. Is that a statement of matters asserted?
No, sir. Sorry. It's not, and, you know, I don't mean to be critical, but one of the things that has happened constantly is that the arguments we're being asked to respond to in day one. The statement of matters asserted repeated Mr. Anderson's allegation.
I'm sorry, apparently we're having some technology issues.
With the podium mic, Doug, would you mind arguing one of the other mics? Apparently these mics are picking up and that one's not.
Oh, where do you want me to go?
No, the online stream.
Online.
There's no mic.
Apparently our mics are picking up, but that one's not. So if we can put him in one of these mics that are picking up, I think that'll fix.
Speak louder if need be. Okay,
Will it work again?
do you want me to keep going, sir? Okay. So this has been a moving target from day one. Mr. Anderson's allegation, which is frankly the only one that is not time barred. Remember, any change to that allegation would be time barred. The only one that was timely filed was Mr. Anderson's allegation. Mr. Anderson's allegation back in 2009 was that in 2000, John Oxendine's campaign accepted contributions from a variety of committee limits for each committee, but were excessive because they were affiliated committees. At every stage in this proceedings, including in these proceedings before and after the preliminary hearing, it was alleged by the commission that the allegation was that these contributions were from affiliated political action committees, that they were excessive because they were affiliated, and they relied on 41A. So, for example, in the statement of matters asserted, Ms. Young just said that they argued that these were one political committee. That's not what it said. Of course, December 22nd order denying the motion for reconsideration states, the Commission's statement of matters asserted alleged that the respondent had violated OCGA 21.541A by accepting campaign contributions from a 10 affiliated action. It's exactly what the Commission's amended complaint that was filed back in 2015 said and how it interpreted Mr. Anderson's complaint. It stated that the Anderson complaint alleged that respondent accepted campaign contributions from 10 political action committees that were over the maximum allowable campaign contribution limits due to the PAC's legal affiliation in violation of 21.541A. The only time anyone has ever separate committees formed one political committee was yourself, sir, at the preliminary hearing. Nobody had that. In addition, and I'll address that directly because that seems to be the principal focal point, that argument is simply incorrect as a matter of law and as a matter of fact, because what the statute says, 21.541A, is that you look to see what contributions were received from which entity. That has to be strictly construed in our favor. The allegations that were made, entities that contributed the funds were the 10 political action committees.
Or, if the statute's ambiguous, we have to give deference to agency interpretation.
The definition of what a statute, that's true under the Supreme Court's most recent precedent. However, the definition of what is ambiguous is extremely narrow. The Supreme Court made it very, very clear that ambiguity is something when you cannot figure it out applying standard principles. I would respectfully submit to you that deference to the agency's interpretation here is not correct. In addition, strict construction. When you're applying your own interpretation as the agency, you must strictly construe the act. The interpretation that was applied at the preliminary hearing, which again had not been raised before or since, is the single broadest interpretation of the act that you could have. Effectively, you are saying that you must, as a candidate, look behind the donations you've actually received to determine whether the people that funded the entities which have contributed to you might somehow be related and affiliated and therefore somehow form a political committee. It's not what the act says. That is a extremely broad. So I would, respectfully submit to you it's incorrect as a matter of law. It's also one that has not been presented. The Commission is bound under appellate precedent by its pleadings, both before and after. And not introduce evidence or argument as Ms. Young has done here, stating something different.
Was there argument before the agency said that it wasn't brought up before or after the preliminary hearing?
It was not. The argument that these formed one political committee was before or after the preliminary hearing before the Commission. And the case law is clear, including a couple of recent Court of Appeals opinions that have been handed down. Houston versus James, a pleader is bound by the allegations of his own pleadings, unless or until removed by amendment, is not permitted to introduce evidence in denial of such admission in judicio. That is exactly what is attempting to happen right now. And I would also, I want to reiterate, it's too late now to go back and try and make a new allegation. That is not what Mr. Anderson alleged. The only allegation that's not time barred here, after 14 years after these transactions took place, is Mr. Anderson's. As the Commission has said, he alleged that these were affiliated committees and therefore violation because they were affiliated committees.
Did you make a preliminary hearing with regard to the interpretation that was advanced with regard to the definition of political committee?
No, sir, I don't think I did because candidly I had never heard the argument Mr. Lane presented. Mr. Lane presented it without having us seen it before. It was very different from what the complaint had presented, and candidly he caught me a little bit off guard. So I was not prepared. I don't know if I actually did or not. To go back and look at the transcript, I don't think I did. But the fact that an argument was not raised at the preliminary stage is irrelevant as to whether or not it's been raised at this point. During the hearing before the ALJ, that argument was not made. There was no need to respond to it. It's been made here today And so I'm responding to it for the record that there's no basis to change the allegation at this point. Couple other quick points. How much more time do I have?
Oh,
12, okay, so we have some time, okay. I also want to remind the commission that, when this case was first filed back in 2009, the first staff attorney for the commission who took a look at this said the exact same thing that the administrative law judge said in 2021, 12 years later, that the legislature chose to penalize donors who have made excessive contributions through affiliated entities. The General Assembly did not choose to penalize the candidates or campaigns and force them to conduct research to determine whether the donors that give money to them are affiliated. Same thing was said in 2009. It was now said by the administrative law judge. The administrative law judge also relied on 2 points in her argument. One was that the concept of affiliation, which is the basis of the Anderson complaint and the statement of matters asserted, and the commission's amended complaint back in 2015, does not include the concept of affiliation. It's not mentioned, and that was the whole basis of the commission and Mr. Anderson's complaint. Second thing she focused on, and just to highlight, that's a totally independent argument from 41C. Ms. Young has focused on 41A and 41C. 41C is relevant in large part because the commission alleged in the statement of matters asserted that these were corporations. 41C says no business entity may make a contribution when aggregated with contributions from affiliated corporations exceeds the limit. Because of the nature of the allegation that was made in the statement of matters asserted, that directly implicated that provision. Ms. Young has also said that the judge erred by concluding that these were business entities. That misstates the definition of a business entity. A business entity is not just a corporation under the Act, it is also a nonprofit organization, so a political action committee can be a business entity. Business entity does not equal corporation. On all these things, but highlighting the basic of this complaint does not exist in 21-541A. The Commission's allegations at all stages of this proceeding dating back to 2009 have been premised on that mistaken legal principle.
Mr. Chalmers, excuse me, so I just want to make sure I understand. Is the Oxendine argument that if it's an affiliated corporation, it's covered by the statute, but if it's an affiliated business entity, it's not?
No, sir. When we have to differentiate between 2 statutes, are we talking about that issue here in this case, or 41C? The judge concluded that 41A did not apply to this case because the allegation was that the described them were affiliated, and the first basis for her granting of the motion to dismiss was that 41A doesn't include the concept of affiliation in it. There's a definition of affiliated committees in the Act. It is not used in 41A. That was the same basis that the staff attorney relied on back in 2009. Second basis for her opinion, independent, was that because the allegation has been made that these are corporations, C specifically talks about no business entity, which includes a corporation or a committee, may make, nothing about receiving, may make a contribution that when aggregated with contributions from affiliated exceed the limits. So her second basis for her conclusion was because these were alleged to be affiliated corporations, that was the provision that would control in this case. And since it only penalizes the donors and not the recipient, it was a second independent ground for her reasoning.
Thank you.
So I'm confused. We keep talking about 41A and 41C. Is it your position that 41C was not argued before the
No, sir, 41C was argued.
Okay.
Well, at the preliminary hearing, a question was raised by Chairman Kreinhall about whether or not these 10 affiliated political action committees, which is what they were alleged to be, the campaign, could somehow deem to be a political committee, one political committee. 41A says that no candidate receive more than the contribution limit from any such entity, and one of the entities it describes is political committee. And so
The reason behind my interpretation was, again, because 21-549, sorry, 6, you know, it talks about that a political committee is any other group of persons or entities which makes a contribution. So I felt like there was a factual issue that may exist.
Understood.
Regarding whether a group of entities made this contribution, and that there was a lot of discussion about that.
I understand, and I, you
And
know,
I'm hearing what you're saying about that, you know, not, hasn't been raised.
it was not raised before the administrative discussed in the initial hearing. That argument was not made. I would also.
Hold on, real
Yes, sir.
quick, Mr. Chalmers. The allegation before the commission, I can't remember, had this preliminary hearing, that was that these groups were an affiliated committee.
Yes, sir.
That's the only allegation.
The only allegation was made by Mr. Anderson, then repeated in the commission's complaint in 2015, was that these contributions, that these were political action committees, that contributions from each one was within the limits, but they were together because they were affiliated under common ownership and control. Excessive. So it was an argument that these were affiliated committees and therefore there's a violation. The Act defines the term affiliated committees. It never uses it, and it doesn't use it in 21-541A. What 41A says, can we go to the first slide, please? So 41A, this is what it says: no person shall make or shall receive from any such entity contributions which exceed the limit. It doesn't talk about affiliated communities. It talks about the entity from which you receive the contributions. The commission alleged in its complaint in the SOMA that these were corporations. It did not allege these were political committees, and frankly, a corporation cannot be a political committee under the law, and therefore the commission's allegation that these are corporations necessarily defeats any suggestion that they are a political committee. It's a matter of law, you're one or the other. When our argument in the preliminary hearing, which frankly I may not have articulated particularly well, which is in fact the case, is that the allegations are that the contributions were received from different entities. They were action committees. They have separate registrations, they're separate organizations, separate checks, different addresses, etc. Strictly construing that, even looking at it, received from an entity, which was these political action committees, more than the limit. So we could not have violated the statute. And also, based on the way the commission presented the case to the ALJ, as a matter of law, we couldn't have, because they alleged that we were a corporation, excuse me, they alleged that every one of those separate 10 entities was a separate corporation, and that we received within the limits from each such corporation.
Mr. Chalmers, I want to make sure I understand your argument.
Yes, sir.
I believe, well, what I'm hearing, and correct me if I'm wrong, is you're asking the commission today parse the difference between a corporation and an entity with respect to 41A and 41C.
No, sir.
Right?
No, sir.
Okay.
I apologize, I'm not understanding the question.
Well, I'm understanding you to draw our attention, we're talking about 41A, right? And in 41C, there is a discussion of no business entity shall make any election contribution to a candidate, which when aggregated with contributions to the same candidate for the same election, et cetera, et cetera. So,
From affiliated corporations, that's the key part of that.
okay,
41C is implicated because they were alleged to be corporations and affiliated, and that's why the judge concluded in part, the second part of her reasoning, that 41C is the statute that would control on these facts, not 41A.
okay, thank you.
But that, 41,
In the statement of matter, no, it's a different argument. What Chairman Kreinbull asked was, did the Attorney General's office, in the statement of matters asserted, allege under 41A that the contributions were received from a political committee, and that all of these entities together form a political committee? That argument was not made. It was not made by Mr. Anderson. It was not made in the commission's amended complaint. I won't repeat myself. Unless there are other questions for me, I would like to leave the last couple of minutes for Mr. Anilowitz to raise a procedural defense.
Thank you, Mr. Chalmers.
A procedural issue, but it is an important one.
As Ms. Young mentioned, this case was referred to an administrative law judge by the commission. Accordingly, the time period for review under OCGA 5013-41, as was mentioned, if an ALJ decision is not ruled upon or commented on by the commission within 30 days, that that ALJ decision becomes the final decision of the agency. Under OCGA 5013-41D4, extend the 30-day period in order to consider the matter later. The agency here, the commission here, on the 29th of December, extended the agency review period, but it did so in a very brief order. And it says the commission pursuant to the authority granted to it hereby extends the commission's agency review period by 30 days. Therefore, the commission agency review period will run from December 29th, 2021 to January 28th, 2022, subject to further order of the commission. The issue with that order is that in order to extend the 30-day period under D4, two things have to occur. Number one is that the commission has to determine that the case in which it is reviewing, that it would render impracticable for the reviewing such a time period. Secondly, any such order shall recite with particularity the circumstances which render it impracticable for the agency to complete its review within such a review period. Here, the agency order extended neither of these things. And because it did neither of these things, the order purporting to extend did not, in fact, do so. And because the ALJ's decision, December the 22nd, 2021, which was more than days ago, the agency's decision is final. And we respectfully submit it was final as of Friday, and that no further review can be held. Thank you.
Thank you.
I have a question. Is there a case, you mentioned the two things that were
Sure.
required, is there a case that you have relied on that where one of these extensions of time to review an administrative law judge?
I haven't seen a case under 5013-41. There's a case under 5013-17, which talks about substantial compliance with the rules, but 5013-41 is more specific in the context of an ALJ decision, and that statute was passed in 2018, which added all of these requirements. And so, no, I haven't seen a case saying that. But if you look at the stricture, it explicitly requires those two things, and those haven't been met here.
What does the case say that you saw for 17, I believe you said?
For 17, it talks about a substantial compliance with the statute, but it was in a different context. I think it's a cab case, and I can get you both the citation. But it's in a different context. And when you have two statutes, 5013-41 and 5013-17, what the case law does say is that the more issue that governs over the more general, and here this would govern over the more general. And clearly, the legislature in 2018, when they added these provisions, was trying to say that there could be only an extension based upon these two things. The cases that cited 5013-17 said that if a penalty is not applied for not complying with the deadlines, then you can maybe have substantial compliance. But in 2018, the General Assembly applied a penalty. Is that no further review is allowed.
That's 5013-41.
Yeah, 5013-41D4.
Be great.
That'd be awesome. Thank you.
Yeah, I've got, so D3 and D4 are going to be operative.
Prepare that here.
we, as the regs indicate, we're going to deliberate in open session.
Yes.
But we're also going to take about I'm going to say a 10-minute break to give all the commissioners an opportunity to absorb everything that was said in the two arguments before we actually begin our public deliberations.
Thank you.
We'll be in, oh, sorry.
Just one very about argument, since I didn't address it in my.
She had how much? 45 seconds. Okay. Mr. Marty said you had 45 seconds, and I did offer you the opportunity for rebuttal, so.
I think that'd be a great argument if the ALJ had not entered an order to look at that 30-day window they entered with a few days left on the quite careful to make sure that within that window.
Ms. Young, when is, in your mind, when does the 30 days expire?
I believe, so
Understand, thank you. Okay, we're going to be in recess for 10 minutes, and then we'll come back to public deliberations. Yeah, I've called the case back to, called the matter back to order, so you have comments, questions?
Just a question. So, Ms. Young, what exactly is the Attorney General's office's argument about how 501341D14 has been satisfied?
I do need to correct him, misstated exactly.
Oh, I'm sorry,
Different order.
This is the procedure, the
The
last
procedural,
Oh, I'm sorry.
Yeah.
Sorry. So we, say that just because you file a motion for reconsideration doesn't mean that 30-day window until we did that. That was 17. That left us with 8 days left in that 30-day window. Motion for reconsideration was ruled on the 22nd. That clock started to run again.
What, 22nd December?
December 22nd, meaning that the, and it would have actually been the 30th.
The argument is the timing. It's what the order says. Is that right?
Right. The argument is, and I understand that the commission came in and got an extension of the original order of the court by asking for a certificate of review and asked that the proceedings. The ALJ then entered, ruled on the motion to reconsider on December the 22nd. That starts the timing of the 30-day period. And timing of the 30-day period then would have ended Friday. The ALJ, I'm sorry, the Attorney General's office did ask for an extension within that 30-day period. The problem is that the extension which was granted did not meet the requirements of D4.
Okay, so that's what I want to talk about. And I may have a question. So again, Ms. Young, how does the order that extended the time, set aside the timing, how does that comply with OCGA 1513?
501341. And that review could not have been completed within
The order, right here, says order extending agency review period. The commission, pursuant to the authority granted by OCGA 5013-17C, 1513-41D4, what we just talked about, in Georgia Regs 189-208, hereby extends the commission's agency review period by 30 days. Therefore, the commission's agency review period will run from December 29th to January 28th, 2022, subject to further order of the commission. It's signed, and then there's a certificate of service. So twice in this statute in D4 it says, any such order shall recite with particularity the circumstances which render it impracticable for the reviewing agency to complete its review within such. Further extend that later in the paragraph, but you have to recite the reasons again. What I just read doesn't do that, does it?
It's at 5013. 501317 applies, as does the commission's rate.
Quinn versus Professional Standards Commission being one of them, that says that, you know, a technical, as you know, ultimately do it.
Sean, contemporaneous with, you know, that order being presented to the commission, did you file the motion for commission review of the initial decision of the administrative law judge?
We did, yes.
And it's a, I don't know, substantively, it's a six-page motion? And it,
That sounds about right,
Okay,
with exhibits and
and it
there was a
sets,
cover letter.
and it sets forth, you know, the reason that you're asking, you know, for review and all the issues that are presented in one, right?
Yes, and as a practical, substantively act on that without,
The order considered in conjunction with the motion, would you consider that substantial compliance with the statutes?
we would.
Okay.
So, all right. In that motion, does it say where ALJ's order within 30 days? Right. So take me back to 501317 in the case you just said, because I cannot see how you satisfied D14. Of the previous statute.
Find the complexity of the issues and the length of. Same provision that the technical not enough to require dismissal of the action.
You said that's the case?
Yeah, and I think in the same position as
You're referring again to the quick case? Or no?
and could have been included in the order. But a technical defect, it doesn't. Under the APA is going to be, you know, something that is going to penalize the agency and prohibit.
Counsel, what would stop the commission at this point from issuing an amended order?
You asking me?
Yes.
I think the rule, the statute. arguments that these other two provisions were cited, they were, first of all, the reg can't trump the statute. We all know. The two statutes, 5013-17. First of all, the more recent statute is unless we just want to completely ignore what the general. Motion, what governs.
Thirteen seventeen C, it doesn't have the same language. We cited it here in the paragraphs. I mean,
No, it does not have the same language. What I'm saying is that it doesn't govern here. If
well,
it-
but that's not, so, okay. Saying two laws on the books, one we have to ignore and one we don't.
No, I'm saying you have two laws on the books. One is applicable and one is not. 5013-41 is applicable because it governs decision. 5013-17 governs an initial review coming from the agency. There is some review back, there's some discussion back and forth between the two. To follow that procedure, and decision, it ticks off what has to occur in order for the extension to apply. As Mr. Chalmers has said, both in his presentation and in our briefing, these, and that's because they are affecting the rights and obligations of Mr. Oxendine and other people that are subject to them. You know, some people call it a technicality. I mean, I just call it what the General Assembly said. And in terms of the prejudice, obviously Mr. Oxendine, a number of years, well over 10 years, with this, at some point it has to stop. And I think that with regard to the ALJ's decision, we went through the process, they asked for reconsideration, and then they did not do what they had to do to get this commission's review.
Counsel,
Yes.
oh, go ahead.
I've just got one, I wanted to clarify one point for me. You drew a distinction between 17 and 41.
Yes.
And you said 41 is more specific with an ALJ order.
Yeah.
Since this is new to me as of this morning, what does 17 apply to specifically?
17, I believe, just applies to initial decisions of the agency. That's what 17 applies to.
So wait, so in that scenario, we make a decision and then we want it back within 30 days, so we don't let the ALJ take it, we don't let OSA take it, we want to
Then
redetermine whatever we did.
Then 17 may apply. I mean, I think because it specifically says what has to be done in order to extend it. That said, there is a case out there that says no, that's not accurate with regard to 17. I'm making that argument as a placeholder, but I think the more accurate argument. And when the General Assembly acted in 2018, you have to give some meaning to that action, and that action is to require these processes.
And does that also concern an ALJ? Does the case you're talking about with subsection 17, does that also concern an ALJ order?
No, I don't believe
Yes,
it does.
it does.
Oh, it does?
I've got the case, it's,
Give me the other podium, come back.
Well, she's doing it.
Yeah, it may, it may. I don't, okay, well, I apologize.
Mr. Chairman, I have a question once we finish this line.
Sure, but I think it's a 2012 case too. But if it does, then I apologize. But again, my main argument is that the statute was changed in 18, it has these requirements. Ms. Young said that the two statutes are in conflict. When they're in conflict, the more specific one applies. I think that that's the more recent and specific one applies. And I think that's an accurate articulation of the law, and I can provide numerous cases to say that.
Yeah, so I got a question, Fred, and I just want you to help clarify the timeline as I understand it.
Absolutely.
I'll ask you some questions and you can kind of fill in the
Yes.
blanks. As I understand it, your argument is that the ALJ's decision was December 22nd, correct?
The ALJs, and I've looked at this, and I think an argument could be made that it's the November decision, but given the fact that they filed a motion for review and asked for essentially what was a stay of the decision, then yes, the argument here today is that it's December 22nd, 2021.
Okay. And on December 29th, the commission's order was issued, correct?
Correct.
And on
Yes.
December 29th, when the commission issued that order, it extended the date until the 28th of January.
Correct.
And was Mr. Oxendine, were you all, his campaign, you all were served with the commission's December 29th order?
Yes.
Correct. And on the 29th or shortly thereafter, after receiving the order, did you file any objections?
No, sir.
Were you aware of 50-1341 at the time you received the order and the argument that you're making today?
I was, but the argument would have been until today, it wasn't late.
When did you receive notice of today's hearing?
On the same day, I think it was the 29th of December. Maybe no, January 4th, maybe?
Did you file an objection?
I did not.
So on January 4th,
Mhm.
you knew that the hearing was going to be on the 28th.
I did.
And you knew that
Sorry, the
your-
24th, yes.
The 24th. And you knew that your argument was going to be that this hearing fell outside of the 30-day window, correct?
If the hearing went forward on that day, yes.
But I'm hearing that you knew that the hearing was going to be
I knew that
today.
it was scheduled for that day, yes.
And you knew it wasn't going to be within the 30 days,
That's right.
and you didn't file an objection.
Not until today, because it wasn't premature. The objection still stands.
Well,
Yeah.
but you knew
I
that
did.
the hearing would fall outside of the 30-day period.
I did.
And you chose not to file an objection.
I did choose not to file an objection.
Why?
Why?
Yes.
Because it's not my job to tell, my job is to protect and advocate for Mr. Oxenden. It was, today the hearing is late. And under the strictures of the statute, it did not, there's no requirement of me to raise it early. The state should have done that. The state should have made sure that the hearing fell within the initial 30 days. It did not do so. The hearing becomes the final order.
All right. I think we've had plenty of discussion
Thank you.
on this, the issue, the timeliness of the hearing and the order. I want to open the matter up for discussion, on the merits. Because if there's I just again would like to hear deliberations with regard to the argument on the merits. And where I'll start on that again is just a comment on my part on the merits, which is that at the preliminary hearing, as I saw it, we found reasonable grounds for a violation under 41A. And we found those reasonable grounds under 41A under an interpretation that was advanced by Mr. Lane initially, that I then sort of ran with, as Mr. Chalmers would indicate. And that was that these 10 separate entities constituted a single political committee. And if they constituted a single political committee, they squarely fell within the definition of 41A. I still think that there's some validity to that argument. But the problem that I've got at this point with it is that in the statement of matters asserted, it was still alleged that it was a violation of 41A because it was an affiliated committee. not for the reasons that we found at the probable cause hearing, that it was that the individual entities constituted a single political committee. Then, again, I'm not sure that it was ever argued to the ALJ, and that explains to me why the ALJ's decisions don't address that point, is that I don't think that it ever came up. With regard to the affiliated committee argument, I may leave that to Commissioner Watts. I don't know if he wants to sort of jump in there, but he articulated that argument, fairly well at the preliminary hearing as to why, if you look at the statute, why affiliated committee doesn't necessarily fall within 41A. So again, that's just sort of my 2 cents worth on talking about the merits. And again, if anyone else wants to, again, offer any comments for deliberation, I would say go ahead.
Stand by what I said.
Well, you may want to articulate that again, because I'm not sure that Commissioner Hicks was on the commission.
I think Mr. Chalmers got to it about halftime of his argument, but given what was argued in front of us and what was in the complaint, as Mr. Chalmers noted, and 540, I don't see how we can, and I didn't previously see how we could find reasonable grounds for this particular argument under 41. We have much less eloquent articulation than I did last time, but the words are in one section and not in another, basically.
Y'all have anything? Yeah.
Mr. Chairman, it would be helpful if maybe I had a deeper understanding of the concerns that you've raised.
Sure.
And articulated before the ALJ. If you could walk me through that, so because I don't want to repeat it.
Absolutely.
Incorrectly.
And again, this is what came up at the preliminary hearing.
Okay.
There was a lot of discussion that took place about whether an affiliated committee fell within the terms of 41A, because the language doesn't speak to that. So there was an argument that was made that, well, an affiliated committees implicitly is included within that. And again, Commissioner Watts took the position, I believe, that, well, implicit doesn't really work particularly well for our act.
Right.
And again, I don't want to put words in your mouth, but
No, that's fine.
Yeah. So then the secondary argument was raised by Mr. Lane that, well, the definition in 41A also includes political committee. Okay, no person, corporation, political committee, or political body. And it says, it then talks about aggregation and those kind of things. So the argument was then that, well, you've got 10 separate PACs. So can the 10 separate PACs actually constitute one political committee? And then if you go back one statute to 21.540, and it's subsection 6, it defines political committee. That definition of political committee includes, it says, or any other group of persons or entities which makes a contribution. Our reasoning, as I understood it at the preliminary hearing, was that, well, these 10 separate PACs could be a group of entities which made this contribution, which exceeded, when you aggregate it, the overall limit.
I recall that discussion.
And Mr. Chalmers argued that, well, contribution is written in the singular, so that's one of the reasons that he doesn't agree with my interpretation. Again, I still think that there is validity to that point, but my concern is in the fact that when the statement of matters asserted was filed with OSA, that wasn't alleged. It was only alleged again that it was an affiliated committee and that the affiliated committee violated 21.541. And I tend to agree with Commissioner Watts on that issue, that I'm not sure that that's
So
within that provision.
one of the things, since we're in deliberation here, my understanding is the ALJ made this ruling but didn't hear any evidence. Is that right?
That's right, it was on motion to dismiss.
Motion
What
to
I
dismiss,
understand.
right?
Yes, sir, Commissioner, this was not, there was a motion to dismiss filed. This failed to state a claim under the Act. Same allegation, or the same argument we had made previously. And, you know, I would highlight for you very briefly, this whole conversation about changing the nature of the allegation flatly violates law if we choose to do that.
Well, I guess I'm trying to get an understanding. At this commission, we had a robust discussion of the term political committee and whether that term should apply and under what circumstances, and we took a vote on that. It doesn't sound like at the ALJ undertook those same considerations of, and I get it that in the statement of matters asserted, the term used was alleged affiliated committee, but it doesn't sound like the ALJ considered the term political committee.
If she did, because it wasn't alleged, and it couldn't be alleged because that wasn't that was not time barred in 2009. If the commission now wants to make an allegation different from that and allege that this was one political committee, you can't do that given the appellate law that says you can't be inconsistent with your pleadings. Recent case law, Houston versus James, cannot introduce facts in contrary to your pleadings. Second thing is,
we're not really introducing facts. We're introducing arguments.
You were contrary to your admissions that you can't introduce evidence and facts. How would you take that point?
Okay.
If in fact the allegation is that these were affiliated committees, and that's how the violation take place, how can you then establish that it was a political committee in support of a different time-barred allegation that's consistent with the one you've already made?
Let me maybe rephrase the paradigm of my question, the framework for my question. This committee today, we as commissioners are determining whether or not the ALJ's decision, whether or not we agree with the ALJ's decision. I'm hearing, Mr. Chalmers, you made the argument that our determination as to whether or not we agree with the ALJ's decision can only be based on the arguments that were made before the ALJ, even though we know that our decision at the preliminary hearing that sent it to the ALJ considered arguments that the ALJ did not consider.
That is correct, because the allegations that you made in the statement of matters asserted were different from the allegations that you're now considering.
But they're no different than the allegations we considered earlier.
There wasn't no allegation. You considered basically what happened at the preliminary hearing was that it was clear that 41A was not going to prevail because the argument that Mr. Anderson made and the commission had made in its complaint in 2015 that these were affiliated committees was going to fail because that's not the law. So what happened was there was a discussion that took place about could we make an allegation? Is there another theory, not previously alleged by Mr. Anderson, not previously alleged by the commission staff, under which
That's not exactly what happened because I was there, but I understand that
Right.
for your client, you need to frame it that way.
I
But for
actually
the record,
believe that's
not
exactly what happened, sir.
We can agree to disagree.
We will.
And then the commission filed a statement of matters asserted.
I'm assuming that you're sort of saying that was something that I did. I don't know if that's where you were going with that, but I will tell you that that's not how that occurred. That was an argument that was advanced by the commission, and that once political committee was mentioned, I looked at the definition.
By commission, I'm including the staff. I'm not specifically intending to disparage anybody. I'm saying that the commission staff raised a new argument and a new theory to try and convince the commission to keep the case alive, which it did, but that theory was inconsistent.
And we agreed with the arguments
A
that were
majority of the
articulated.
commission agreed that there were reasonable grounds to believe they could move forward on that basis.
And we sent it to the ALJ.
Right.
And the ALJ did not consider the arguments and some of the language and the statutes that were decided at the preliminary hearing.
Because your lawyer filed a different allegation.
I understand. We're now back,
Right.
right? I'm trying to get an understanding of whether or not, and I'd like to get some of the other commissioners to weigh in if you have a thought. The ALJ did not consider, as I understand it, political committee in their decision, and whether or not there was a violation of 21.540 or 21.541 based on the phrase political committee. Only alleged affiliated committee was argued. And I'm trying to get an understanding, I'm trying to get my head around whether we are bound or the language put forth in the statement of matters asserted when we know that our decision was based upon other language.
So
I'm sorry, I'm not sure there was a question direct.
I think
Well,
you-
we're in
I think it was-
deliberation, so I
yeah.
guess I'm, that's what I'm trying to get my head
That's
around.
actually accurate.
Yeah,
The ALJ could not have considered, it wasn't raised.
I understand.
So, I mean, I think I've been clear about this from the very beginning since I've been on the commission, but it matters what is alleged, and that is what is before us. And, you know, a whole host of things can be alleged, but it matters what is alleged. And that, the last time we had this discussion, was what I was focused on.
Understood.
So procedurally, I have a question. So can we not, because if, what Mr. Chalmers is saying is that we can't go forward because basically, and I'm bringing it down a little bit, we can't go forward because what we're saying, the commission voted on one thing, and I did recuse myself, but I'm talking procedurally. Voted on one thing. However, those things that we voted on were not in what went in front of the administrative law judge. Is that correct?
That argument is correct, yes.
And that's why you're saying we shouldn't go forward or throw this out.
That's what I'm
Procedurally, can we not dismiss or disagree with the ALJ and then refile with the ALJ for the specific allegations that the commission did set down?
No, sir. Under the OSA rules, there's a time period in which you can amend a pleading. It exists, it passed, it's long since passed. You have to, in order to amend the pleading, you have to get the permission of the court. None was ever requested. If in fact you were now, after the initial decision, the initial decision, the review that you're supposed to determine is whether the ALJ ruling based on the allegations that were presented is correct. If in fact and start a new case, that would have its own statute of limitations, considerations, etc.
A question to the Attorney General's office. Do
Yeah,
you
I think
agree or
that's a-
disagree that the, and I don't think you were our AG at the time, but I'm sure there was a transcript. I think you came on after. Agree that what the commission voted on to move forward to OSA, was that included in what you filed?
Not as expressly as I'd like for it to be, knowing what I know now today. However, you've been misadvised. So where, you know, the fact that we didn't plead something expressly in the SMA prohibits the, under OSA rules, you can amend your
To support or amend or reject what
We are.
the OSA judge is doing, and if it's a different.
We are,
Makes
because
more
in my mind, right, it's decide whether our review can be de novo review, meaning can we review the ALJ's decision limited only to what the arguments are, or can we review the ALJ's decision anew, meaning considering everything that we know about the record, considering everything that's in the record, evidentiary or otherwise, procedural or otherwise, can we look at the ALJ's decision and agree or disagree based solely on what the ALJ considered, which would include the arguments made? Or can we make a decision to affirm or agree or disagree with the ALJ's decision based upon the record in its entirety? I think that's the question.
Well, again, I'm going to agree with Mr. Chalmers on one point, and that's that, I mean, or I don't know, you tell me if I'm characterizing this correctly. There was only one question, really, before the ALJ, and it was the affiliated committee question. There was no question before the ALJ about whether all the individual entities constituted a single political party.
Yes,
I mean,
that's correct.
So if we're looking at an order or two orders, you know, with the motion on reconsideration also, you know, the only thing the ALJ addressed was the affiliated committee. So that's the only thing that I think we can modify. I don't think that we can just.
If the commission would like to do so, the ALJ had, you could order the case to go back to the ALJ and direct us to file an amended SMOD. There's nothing at all that would prohibit the commission. That's what the commission is interested in doing.
Can we also remand to the ALJ with instruction to consider 21-541 and 21-540 as we did at the preliminary hearing?
Absolutely. There's absolutely no provision either under the APA.
No, sir, you cannot, because that would be a de facto amendment of the pleading. It would be a de facto amendment of the SOMA. It would be a de facto amendment of Mr. Anderson's complaint, which is the only allegation. It's not time barred at this point. There has been, the case law is clear that you are bound by what you admit in any meetings. This case is one where, starting in 2009, the allegation was that these were affiliated committees. And I don't believe I'll go back and get a second bite at the apple, ask that consider arguments that Mr. Anderson didn't make, not in the SOMA. If you want to do that, you need to start a new case alleging something different from what has been alleged for the past 12 years. And if that was done, we wouldn't have the procedural argument we have here that it's we're in the final review. But we would in fact have a argument. This is a new allegation that is time barred. These transactions happened in 2008, 14 years ago.
And Mr. Chalmers, and we're still talking about it. I would agree. I respect and I think you're probably right. I think you might be conflating two concepts or two issues that I'm trying to get at. You're absolutely right that the staff, and when you say you, the commission, can't go back and amend the complaint after the fact. What I'm we aren't determining what's in and what is not in the allegations. Right?
Actually, you are, sir. It's your lawyer filing on behalf, it's an odd situation. Your
Yeah.
lawyer files on behalf of the commission.
Yeah.
The commission alleges, and then the commission rules. It's a little bit of an odd proceeding.
Here's what I'm trying to get at, and ultimately, I may find agreement with you. I'm trying to get some guidance, or trying to get some input on, to the extent we are going to agree or disagree with the ALJ's decision, it would benefit this commission. If I had an understanding of whether or not the ALJ considered all of the issues and the arguments that we considered in the preliminary hearing, okay? And if the ALJ did and came to their decision, that informs me. If they did not and came to its decision, that likewise informs me. If they did not consider all the evidence and arguments made at the preliminary hearing, I would like them to. That's where I'm getting at. And they may or may not come down the same, but but it doesn't sound like they considered all the arguments and the issues that we considered at the preliminary hearing. And it would be a benefit to me to know that they did. Or, you know, that they chose not to. That's the issue that I'm having here. I'm trying to get an understanding and how I might rule as to whether or not the ALJ did all the things that we did.
That's, Commissioner, with respect, and I understand that, and if I was on the commission, I would probably want to know what a judge thought on these issues. That is basically saying, is there another theory that Mr. Anderson could have pursued, that the commission could have pursued, the Attorney General's office could have pursued, that might have prevailed in this case? Is it possible that was the case? That's not how litigation and administrative proceedings work. We've been in this for 12 years. The commission has had multiple opportunities to make the allegations it wanted. It is long since past time for Mr. Oxendine time barred if it's brought up now. Whether there might have been could have presented, you're here today to decide whether or not the case that has been litigated for 12 years reached the right conclusion before the ALJ. The judge, the argument she was presented was Mr. R. Anderson's argument.
Thank you. No, that's helpful. Thank you.
Do we have any other comments? Someone will make a motion. I make a motion that, that we accept the decision of the administrative law judge on the, in the memorandum of opinion and order on motion to dismiss and the order denying petitioner's motion for reconsideration. That was in OSA case number 2125871. Second, do we have any discussion on that? Hearing no discussion, I'm going to go ahead and call the question. All in favor say aye.
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 All opposed?
No.
And you're recusing? Okay. For the record, Commissioner Thompson is recusing. We have a nay from Vice Chair Barnum. That'll conclude that review matter. I did not anticipate by any means that was going to go that long.
Sure you did.
What do you guys want to do? I'm open for discussions. You ready to go plow through or what?
I didn't order lunch, so if you want.
Let's plow through that.
Okay. Y'all good to go?
Yes, sir.
Okay. All right, I'll go ahead and,
A lot of the procedural stuff is good.
yes. I mean, I'm assuming that that'll be raised again.
Yeah, but we don't have to have that whole thing.
Yeah, if it's the same, let's just cut that off.
Right.
Yeah, well, I'll just go. All right, I'm going to go ahead and call then for our review hearing, case number 2017-0169. Again, this is in the matter of John Oxendine. Ms. Young, go ahead and proceed.
Question of whether or not an action has been commenced. There's a 5-year statute of limitations. Filing of a third-party complaint and acceptance. The person has violated the act. File an appellate court cases. So we've asked the commission to determine if this case has ever been commenced. Commission initiated. After Mr. Oxendine failed to win the Republican nomination, he had a lot. Somehow it was noticed that there were some unaccounted for funds of $208,000. And expenditures you would have expected and to have. But a CCDR was showing that he only had $542,000 and change in the bank, and so the commission asked the question why.
I'm gonna do the same thing.
Sure.
I apologize, Ms. Young.
And I will.
I want, again, that one went a lot longer than we anticipated. We know what the facts are, because we've had this case before us already. I'm gonna move in. I've just got, right to the point. I've got a couple of questions that I need to
I
ask.
do know that not everybody was here for the.
Daryl's like,
Yeah.
I'd like to hear the facts.
Well, my only position is that if you want me to have an opinion on it, I need to know the circumstances.
All right, go ahead.
But my one, before we march
sorry.
down this path, because this is also a presentation, not yours, that I tried to cut off a long time ago, but, so, is the only thing at issue the statute of limitations argument?
This is the only thing at issue, and did.
Well, I don't want to interrupt you, but I don't think that that's the only issue. That's why I wanted to, I think that Mr. Chalmers raised a couple of additional points that were also addressed by the ALJ. And I don't know where this sort of came from. I'm kind of going back to the statement of matters asserted again, because my review of what happened, and we'll go back to the facts and the background, I promise. But my understanding was that we found probable cause on 33 A and C, right?
I believe.
And then I saw in the statement of matters asserted, there's a couple of allegations from 34.
Those. Intending that the commission should.
That's
review that.
right, that's fine. That's why I said I wanted to get right to the point on that. So you guys are conceding that those allegations under 34 should not have been made.
Correct.
Okay. And then I think that there were some other code sections that were also cited along with 33A and C in the statement of matters asserted. And it's escaping me what provisions they were, but I know that Mr. Chalmers, he'll tell us because he raised it in his brief. You're conceding that those don't apply either, because again, the only thing that we found probable cause on was 33A and C.
I believe that's correct, and we're not, we were not contending that our SMA did probably cite other provisions, but
That's fine.
the meat of the allegations and what found to have reasonable cause to have violated this three.
Now the only issue is statute of limitation as to those allegations.
Yes,
All right, go ahead.
and have we ever commenced a case?
Okay.
And if not, how might one do so in the future?
Okay.
Dine after being on the receiving end of some unfavorable news articles, which the commission actually tried to amend the 2009 case complaint to include and it back right away with interest. So that amendment might explain went, but it doesn't reflect on to stop the commission from pursuing this action. From the bank that several years at this point, and learns from that what this investment in personal residence in the amount of $97,000, covering some shortfalls in his trust account. Paying for semi contributions, vehicle lease payment. Especially set hearing. This case with OSA by filing case initiating documents, and over the course of 6 final evidentiary hearing. Jay finds that none of these steps were violations that have been alleged in the we're going to have a hearing about the allegations of the complaint. We have to include a specific and she also pointed out that 2156B 10B Chapter 13 of Title 50. After the preliminary hearing qualify if the believe you have violated this statute and we are sending you for further prosecution. There's going to be a hearing under the APA. Tell Mr. Oxentine that he can this is 5013 tested case hearing. Statement of time, place, statute, SMA, and a statement about subpoenaing witnesses. She said that we basically can send such a notice. particular hearing notice provision applies to, but it applies to the final APA. Although, certainly the commission would have to give fundamental due process. Office can actually do it. If the ALJ is correct, we have to or how a commission is commenced. A third-party complaint, put it in an envelope, serve it upon the respondent, case is commenced. But if it's a commission-initiated complaint, basic rules of statutory construction. And we are in the place that we simply don't have the ability to do that. They did not want to handcuff the commission so that you could only statute so where the commission can't do contested hearings, the final evidence that the particular statute requirements of 501313 don't apply. Title IX has had lots of notices and lots of process here. So we would have with the ALJ's opinion.
Two questions real quick. First, what's your contention as to when the statute of limitation began ticking?
So that is another question that is, you know.
Mr. Chalmers says that it's October 2015. What do you say?
I think that it's somewhat later than that. Get a subpoena, you know.
I think it's very important to know when that was. I mean, you have a, I mean,
it was definitely quite a bit.
2018 when you got the result, when you got the documents from the subpoena.
It was after the Dime case in the Court of Appeals.
So So if that's when the commission
I
first.
can get the exact date.
All right, well,
for you.
you may want to look for that, but if that was the date upon which the commission first had notice of some alleged problem with Mr. Oxendine's filings, and if we apply the 5 years from 2018, we're still within the statute of limitation, right?
Correct. We would also take the position nothing expressly either affirming or prohibiting under the APA. Kind of across the board, we see no reason why a court would not extend
Next question is, what's your position as to when the statute is satisfied? You know, at what point, what has to happen?
That's a good question. Opportunity to respond, which, you know, Mr. Oxendine's counsel did. It was not a full evidentiary hearing, but it was a hearing. A criminal or civil statute. There's, in civil world, you how to commence an action.
The preliminary hearing in this case was in August of 2019, so presumably notice was sent out sometime that summer.
Correct. And the order after.
Yeah?
That was the other argument that we made, that you look at
Even though they said that we didn't comply, or that the commission didn't comply with, I guess, A2A, which is a statement of the time, place, and nature of the hearing, it did say that it was being referred to OSA, you know, for a hearing. It didn't, it may not have had a date and time, but that it was going to be referred there for a hearing.
for further prosecution
Right.
under the APA. Further prosecution indicating, and
Thank you, Michelle. Mr. Chalmers? And
Mr. Chairman.
I assume that we're making the same procedural argument in this case that we did in the last.
We are, and I was going to leave the last 2 minutes for Mr. Anulowicz. Can we simply incorporate by reference the argument we made with respect to the timeliness of the, or the sufficiency of the notice, the order extending the review period?
That's perfectly fine with me.
Okay, any objection, Michelle? Again, we're dealing with a moving target. Ms. Young said directly to the of the act in this case, based merely on the loans themselves, which were disclosed in 2015, without us having to show what happened with the funds or what was used with the funds. At every stage of this proceeding, including in its complaint filed in 2017, 2 years after the disclosure reports were filed listing that this complaint is timely filed because it is being filed within 5 years of the date that the disclosed.
So where's your starting point?
October of 2015. October 30th, 2015, which is when the amended disclosure reports were filed. And that's necessarily true. The judge found that the tolling argument was also not only untimely raised, in her argument it was implausible, because the commission has at every stage in this proceedings alleged that it was the transactions that were disclosed on the disclosure reports that were the violations, and the clock began to run then. Now let's
So
talk
it was
about
obvious from those filings in October of 2015 that those were characterized as loans?
that they were violations of 33A and 33C.
But
And
no,
then-
I mean, I appreciate that, but that wasn't, I mean, was it clear from the filings that those were considered by Mr. Oxendine to be loans?
Yes.
To his,
It was an investment. It was, the act doesn't define the term loan. It uses the term investment. So the disclosure report said investment for a return of interest, basically defining it as a loan. And so the commission was on notice. In fact, 6 weeks after the disclosure reports were on file, Mr. Ritter, who was then the commission's executive secretary, went on record saying 2015.
I know where on the record, in the press, or where do you say?
We mentioned that to the commission. Where is it on the record?
Yeah.
Mentioned in one of the filings in a different case, and we cited it to the ALJ in this case, in one of our pleadings below. The commission had, I think it was the response to the motion for reconsideration. So the commission basically took the position, and at the preliminary hearing, you all heard all the evidence about what was done with the funds. I'm not conceding what was done with the funds. You heard all that evidence. The motion A and 33C were violated. I believe this was the motion. When the transactions occurred between Oxendine working for Georgia and John Oxendine PC. Those were the transactions disclosed on 2015 on the disclosure reports. Now let's talk a little bit about why that makes some sense. Under 33, the violation is use of funds for anything other than ordinary and necessary campaign or official purposes. It is not personal use. It is anything other than campaign or official use. We raise purely legal defenses below, and that statute is not implicated when there's an investment. A loan or a purchase of stock, a purchase of a Coca-Cola bond is perfectly legal, even though that is ordinary and necessary expense of the campaign. It's an investment. By a split vote, the commission rejected that argument and moved forward. But it still moved forward on the basis that the violation occurred when the funds were transferred from John Oxendine working for Georgia to John Oxendine PC. Under 33C, Mr. Lane and Ms. Young repeatedly refer to this. It is not. What it says is that campaign funds shall not constitute personal assets of the candidate. It's a conversion provision. The position the commission has taken at every point in these proceedings, both before and after the preliminary hearing, was that that statute was violated and from the campaign to a business owned by Mr. Oxendine.
Can I interrupt?
Yeah.
Why are we hearing this argument instead of the statute of limitations?
Because Ms. Young said that the commission chairman asked, when does the clock start to run? And I'm highlighting the point, contrary to what Ms. Young said, it actually started to run in October 2015, given the allegations that were made.
Since we stopped for a second, I'm going to ask my next question of you, which is, and I think I already know what you're going to say on this one, but is it your position that the statute has not yet, we've not yet reached the point where it stopped? Because there hasn't been an order from OSA establishing a hearing date?
The commission has not yet complied with 21.5.13.2.
So is it your position that you know, that like, if in fact 5 years hadn't run based on your argument, that the commission still would not have satisfied the statute?
Correct, has not. And the
How
argument,
do we do it then?
very simple. Let's go back and take a look at the statute. Another one of those examples where, as the ALJ found, the commission's pleadings are, in the judge's words, riddled with an inordinate number of errors. This is the statute that describes how an action is commenced. This act, Ms. Young continues to talk about substantial compliance. She never tells the commission that the APA and the Campaign Finance Commission must be strictly construed in favor of the respondent. That is in fact the case law. There are two ways you can start. Number one, subsection at the bottom down there, is when the commission receives a verified years, the commission former lawyer, not Ms. Young, but the former lawyer who we were dealing with, argued staff complaint met the statute. In this case, the complaint that the staff filed in 2017 took that position. It said the allegations are that these transactions on the disclosure reports were the violation. Clock started to run then. We have now met and commenced the action under subsection 1. Therefore, this action is timely. That was incorrect. The commission has taken that position in a lot of its cases. We have argued with the former lawyer for years that it's when the commission initiates an action, it must be subsection 2. When we got to the APA proceedings here, the commission's attorney currently agreed and did not attempt to assert an argument under subsection 1. So the commission didn't know how to commence an action under subsection 2. It thought it had commenced the action under subsection 1 and never tried to commence the action within 5 years under subsection 2.
Give me 1 second.
Yes, sir.
I just wanted to- Is that right? We did, no argument was made under 21.513.1? Okay. All right, go ahead.
And not before I recognize that it may have been argued at some.
It is asserted in every single one of the commission staff complaints in the footnote. They're still doing that, but it was not argued in this case.
Okay, go ahead.
And so, how do you get to how does the Attorney General or Commission meet subsection 2? Well, it's very easy. The Commission or the Attorney General has to serve a notice that complies with the APA. The APA spells out what the notice must contain. A notice of preliminary hearing cannot meet this requirement because it is served before the preliminary hearing. Under the Commission's rules, it becomes a contested case, and this notice provision applies. The entire argument that the notice of preliminary hearing was a notice served pursuant to the APA is simply incorrect. Now, the Commission, in its motion for review, and in some of its arguments in the motion for reconsideration, stated, Your Honor, under this interpretation of the law, it's literally impossible for us to comply with the act and commence the action. Actually, 3. Number 1, the Commission can do that because you don't have to send a case to OSA. As the argument that's being made is this is a ridiculous interpretation that never could be complied with because we can't do it. Of course you can do it. The Commission has the authority under the APA, under the Campaign Finance Act, and under the statutes to conduct the initial hearing itself. So you can always do this. The second argument is the factual. The Commission never attempted to comply with this before the deadline. It simply let the deadline expire, thinking it had already commenced the action under subsection 1. And so this is not a case where they were thinking they'd comply with 2, they thought they'd comply with 1. I want to show you the timeline very briefly, then if you have any questions, I'll answer them. But then I'm going to turn it over to Mr. Ask the third argument, which is the Commission argues that it's impossible to have the case go before OSA and then get it timely done because under OSA's rules, the PowerPoint doesn't. But under the OSA's rules, it's the ALJ law, where a plaintiff has to get a court or someone else to issue something like a summons, and then have to serve it timely in order to initiate an action. In this case, the Commission had 5 years. It took 5 years and 8 months to get from the point where the disclosure reports were filed initiating the APA proceedings. That's untimely.
I'm sorry, I'm still stuck on the 2017 complaint to some degree. I just want to make sure again. So it's never been argued that the 2017 complaint in this case satisfied the statute?
It was not argued by your attorney before the ALJ. That's correct. The reason it wasn't is because it doesn't. Sorry, answer your question.
I don't want to, I'm trying to say, I understand your substantive argument on that. I've heard it before. I'm just trying to I'm trying to figure out where we are in this case, because that was been a burning question for me for a long time. What effect does the 2017 complaint have on this case? But you're saying that argument was never made, and so the reliance was only on subpart 2.
Correct. Yes, sir. To address the third issue, which is, if in fact the commission sends a case to OSA, is there a way for the statute of limitations to be met? Ms. Young has said, no, it's technically impossible, therefore the ALJ's interpretation of the statute necessarily is inconsistent with the General Assembly's intention, and you shouldn't follow it. I'm going to let Mr. Nicholas address that.
Initiating the proceeding, OSA, in the filing of the statement of matters asserted, y'all's position, that's not even enough to satisfy the statute.
One, factually, in this case, it wasn't done within 5 years. Second thing is, it can be done. It can in fact be done. If in fact the statement of matters asserted is filed with OSA, and you request that the judge, ALJ, set a date for a notice of hearing, you can then serve a notice that complies with OSA, with the APA. It has the notice of the hearing, statement of matters asserted, the allegations, etc.
But the two parts of 513.13a that you say haven't been complied with,
Right.
was a statement of the time, place, and nature of the hearing, right?
And the last part where they never say
Yeah,
the
that's what I
judge.
said, I know that.
Right.
The right to subpoena witnesses. That establishes that you've got to act, that means, January 23rd at 10 o'clock, for some type of hearing, or, it just seems to me for that provision that when you have an order that says that this matter is being referred to OSA for further prosecution, that certainly satisfies that provision.
Does it spell out the date and place of the hearing?
No, but again, that can't be set up by that order. That can't be established.
That's why that order doesn't meet that definition doesn't commence an action of the statute that way. I mean, you're veering into the substantial compliance. We sort of did a lot of these things were really close to what the statute requires. This statute is strictly construed, both the APA and the Campaign Finance Act. It says that in order to commence an action, when the commission itself initiates a case, months went by. The former lawyer that I had previously been arguing this case with forever, that time expired, left public service, and handed the case to Ms. Young. And unfortunately for Ms. Young, the deadline had already expired. As to the question which I think you're focused on about whether the statement of matter, whether the filing of the APA process can start the clock and how that works, I'm going to let Mr. Lewis answer that.
All right, good.
Thank you. Just very briefly, I think that the state has admitted, and Mr. Chalmers has gone through, what is required to commence an action. It's in 21.513, and it has to meet the strictures per 21.513.2 of the of 50.13.13, and I think we all agree that all those provisions have not been met. The argument that the state makes is, well, we could not have done it ourselves. It could only have been done by OSA, and accordingly, how could we possibly comply? First of all, as Mr. Chalmers has stated, a notice could be sent out by the Attorney General's office or by the Commission once the dates have been set, providing for the language in 50.13.13. Moreover, even if it was something that only the state could have requested that OSA do it, and it is within their control. There are a couple of analogous statutes on the books. The first one that I'm familiar with is OSA 12524F, and that's in an election contest. In an election contest, a service has to be made within 5 days of filing the election contest. That service is required to be sent by the clerk of the Superior Court in which the election contest. The case law said challengers have argued in the past that when that notice is not sent, that how could it be their fault because they are not in control, the clerk of the Superior Court is. And in Swain versus Thompson, 281 Georgia 3031 2006 case, the Georgia Supreme Court said that the statute says what it says. The notice has to get filed, and it is incumbent upon the petitioner filing that election contest to make sure that the service is made within that 5 days. Another similar provision is in the civil asset forfeiture context.
Without going into the similar provisions, just tell me in layman's terms, if we refer cases over to OSA, how do you guys contend that we satisfy this statute?
And I'm not trying to be glib, I think it's just by meeting the standards of the statute. So if it goes over to OSA, then you have the requirements that are to be sent out in the notice. A notice needs to be sent out. That notice, once the time, hearing, and everything gets done by the court, can be sent out by the Attorney General's office or by the commission, or if it's required to be sent out by the OSA, then on OSA letterhead, the ALJ can send out that notice. It's just incumbent upon the Attorney General's office or the commission to make sure that that notice gets out from OSA. And that's very similar to other provisions in the law.
Is that the way that this regularly applies to other agencies that refer these types of cases to OSA?
I don't know with regard to other agencies that refer the cases to OSA if there's a similar requirement. I would assume that they do. My analogies are just with other places where people have kind of thrown up their hands and say, how am I supposed to get this done? And the courts have said, will you press forward to get it done? And you make sure that it gets done.
So is the crux of your argument in this case, is it actually the timing of the filing of the statement of matters asserted, or is it that we never got a formal hearing notice that complies with this requirement from the EPA?
I think it's concerning the factual issues. This is not a case that should try before the deadline expired to comply. And then said, we tried, but we couldn't get it served. That might be a little bit possible, maybe relevant for future cases, but in this case, it's a red herring because there was served.
Well, hey, I think it is important because I guarantee you that if we were to, just accept this ALJ's opinion as written to say that, that even to this day, the statute is still ticking along on this because there's been no order. That, you're going to be arguing this down the road, saying that.
That may be important for other future cases.
Well, I think it's very important to establish, how we need to address this particular order, whether we accept it, modify it, or whatever. Are we going to make it the rule now, for our commission that when this thing goes over there, that the statute's it's not satisfied by the filing of the statement of matters asserted. It's not, satisfied by the filing of anything other than some type of notice that fully complies with this, that includes the time of a hearing.
I think that I think it's admirable that you're looking, Okay, I think it's admirable that you're looking to establish a precedent that makes sense. Here today is to determine whether or not this case
accept the ALJ's opinion in this case. You're not going to be coming before us in any other cases and say, oh, but you accepted that ALJ's decision, and now that's how you have to do it.
No, I will.
Of course you will.
Of course. But again, you don't need to do that in order to resolve the case. Again, this has been a little bit of a different situation if you attempted. Using the word you, I don't mean to be rude or improper, but the commission and for its former counsel let the clock expire. And I don't think that that the question of how you commence an action under the APA is really relevant in circumstances where there was no compliance. The judge's order in this case basically says that the notice of preliminary hearing, which was the first argument, as Ms. Young noted, they changed their arguments as they went for it, doesn't apply. The complaint, notice of preliminary hearing, and the order after the preliminary hearing doesn't comply. She didn't say exactly how you can't, said that those don't do it. And I think letting that stand, frankly, gives you an opportunity to either go to the legislature and get it changed, or issue an advisory opinion, or in the future, make sure that your counsel files it within the 5 years and asks the ALJ for a date of hearing, so you can then serve a notice that complies within the statute of limitations, much like, as Mr. Anulowitz said, it's done throughout the law.
Thank you. I think we're gonna do the same thing. We're gonna take a 10-minute break to kind of decompress and absorb this, and then we'll come back and we'll have our deliberations.
Mr. Chairman, may I just to clarify for the record, we talked about incorporation by reference of that first argument. I want to make very clear that we're talking about the argument that Mr. Anulowitz raised in the 2009 case, argued today, that the statutes, that the commission's order extending the review period did not comply with OCGA 50-13-41D4, and therefore the administrative law judge's decision in this case became final 3 days ago on the 21st.
Okay, thank you. I will recess for 10 minutes.
Ready to go, so let me know when we're back up.
Yeah, we're going to call the matter back to order. It's time now for our public deliberation over 2017-0169 EC. Got it.
Yeah, Mr. Chairman, before we get to the merits, I think we should probably address the Oxendine campaign's argument or position that the December 29th, 2021 order extending the time for this body to consider is or is not properly I think we probably need to decide that issue. We didn't before, but my guess is, and Mr. Oxendine may have, Mr. Chalmers may have a different position, but because the vote was to adopt the administrative judge's ruling, whether or not we're here properly, he may or may not choose to challenge that. But to the extent we decide differently, I think there's an unresolved issue as to whether or not this hearing is proper, and we need to consider that first.
Given the commission's ruling on the merits of the argument in the previous hearing, I think that issue is moved for that purpose, but I would request a ruling on this hearing if the commission is,
Yeah. So, and my position is that this hearing is, that it's proper, that we're here, that all parties were on notice of the hearing date. It does cause, I focus on the idea that there was an opportunity to raise any objections to this hearing. There was an opportunity to point to the timeliness or the delay in this hearing, and no such arguments were made. So it suggests to me that while all parties were aware, there was an opportunity to object to the notice and to the hearing date and time. No objections were made. So in my opinion, I think we're here properly, and all parties have had an opportunity to suggest otherwise and didn't do so. But other people may feel different.
Any other discussion then on the procedural issue as to, it's actually, I guess the issue is to whether the order has already become final and is not proper for review at this point. Any other discussion on that? Do we have a motion? He's requested a ruling. I don't know if we necessarily have to. I think it's a defense to our review. I think that if we take the action, on agency review, depending on what the action may be, it would then be implicit in that as to whether we accepted or rejected. Well, it would be implicit in that as to whether we rejected that argument if we chose to accept to reject or modify that order. But again, being this is, we've sort of got this public deliberation thing going. If we want to go ahead and make a motion on that specifically, I'll certainly listen to the motion.
Let me find that. I move that find that the notice or the order move that we find that the order extending agency review period that was entered December 29th, 2021, and served on or about the same day is in fact proper, and that this commission is acting within its authority to conduct today's hearing.
We got a second. Do we have any discussion? Hearing no discussion, I'll go ahead and call the question. All in favor of the motion say aye.
Aye.
Any opposed? Hearing none, motion passes 5-0. So we'll go ahead and move on then into the deliberations to the merits of that same case. Do we have any discussion at this point with regard to the merits of the arguments that have been made and the administrative law judge's opinions below? Nothing? No questions for counsel?
I do have a question. Let me just clarify something that I think I understand. Young, is it the staff's position, well, let me just clarify what I understand the staff's position to be. That the disclosure in 2015, that there was this idea that these funds were an investment, that this, we've talked about the money at issue being an investment, and that was a term used in 2015. Is that correct? The commission, when did the commission staff find out about the use of this money as an investment? Because that's really the question. When did we learn about it?
Oh, yeah.
That's 2018.
Okay.
And, they're violating the statute. One is a straight up, you just can't lend money to your own law firm, period. To personal use case.
Okay. But
So.
Ms. Young, I'm hearing Mr. Chalmers say that the use of those funds for, whether as an investment or a loan, okay, the use of those funds occurred in 2015, and that is the date that we should consider as the date that the violation occurred, and a case has to be brought within 5 years. Is that what you understand, Mr. Chalmers, to be saying? Okay. I assume that that you or the commission staff disagrees with that date.
We continue that if that is that the commission did of litigation to prevent
in your arguments, I believe you used the word concealment. I wrote down concealing certain facts. Can you give some more context to that?
well, so $200,000 suddenly seemed to. And after that violation was made part. return of interest, and in my law firm, that was really all that was disclosed.
If I'm remembering back to the preliminary hearing, at some point we learned, or the commission staff learned about that through bank records. Am I remembering that correctly?
Yes.
Okay, and what's the timeline on that?
2018. July 23rd, 2018, we got the subpoena response from.
Can you remind me what those statements indicated?
Oxendine never really.
That's what I'm asking, Ms. Young, is what?
Oh, the bank statements? Deposit on his personal residence on to the law firm account and straight over to Coldwell Banker Real Estate. Collections interest, but also coming out of that same account.
I recall in your slide, there was a listing. Could you go to that slide, please? I'm sorry, Commissioner Hicks, sorry to interrupt there.
I can try.
Okay.
Payments.
So my next question is, does the law allow you to use campaign contributions for those types of investments?
No. Absolutely not.
Commissioner Hicks.
I actually have a different question for you. But,
Go ahead and address that, and then.
yeah.
I'd like to address
Yeah.
those very briefly.
Ms. Young has misstated the record. On the question of when the clock began to run on the allegations, this is what the commission said in its response to respondent's motion to dismiss, page 15, Ms. Young's signature on it. By sending Oxendine the notice of specially set hearing in June of 2019, within 5 years of the date that Oxendine first filed the CCDRs, the disclosure reports, that contained the violation, October 2015. Therefore, the case was initiated. Now she's arguing that no, it may have started in 17 or 18.
No. Those are the CCDRs that contain the violation.
Correct, and that's
I know,
when
but
the
she
statute
didn't-
starts
She
to
didn't
run.
say that they became aware of that in 2015.
How could you not become aware of here? You could allege what was used with, what was done with the money was a violation from the campaign in the first instance was the violation. That is exactly what you alleged, the latter of those. Commissioner Barnum is now focusing on these transactions that took place in 13. All the money was refunded in 15 with $9,000. You're focusing on those transactions, notwithstanding the fact, when you heard that in 2019, the motion you introduced was a motion to find reasonable grounds to believe that 33A and 33C were violated with the transactions that had been disclosed on the disclosure reports. The preliminary order actually says the transactions disclosed on disclosure reports. So in the hearing before the ALJ, it was argued that it was the conversion of the funds took place when they were taken from the campaign. This is not a normal case where the campaign spends money on personal assets and now you're focusing on whether the violation took place then. As Mr. Lane said at the last hearing, this is a case of first impression. The argument was that the funds were taken to a business owned by the candidate and then used for a variety of different things. It doesn't matter for purposes of conversion whether or not these funds were used for anything. Theoretically, if that was a conversion, your argument, your allegation,
Mr. Chalmers,
that was disclosed.
is there any proper transfer of funds? Could there be any proper transfer of funds between the campaign and the law firm? Under any set of circumstances, would there be any proper transfer of funds from the campaign to the law firm?
Two responses. Number one, yes, and we argued that at the 2019 preliminary hearing. Number two, that's not the issue before you.
So
Based on the allegations, you cannot, and that's what the ALJ found.
if your admission then is that there could be a proper transfer of funds from the campaign to the law firm, how would the commission determine if that transfer of funds from the campaign to the law firm was proper or improper unless it understood the nature of that transfer?
Because anytime there is a loan, the funds are going to be used by the lendee for the lender's purposes, or official or campaign purposes. And so therefore, if the whole premise know these were going to be used for other purposes, even though we contend they were converted when they were taken, and we allege that they were improperly used for ordinary necessary expenses, something other than that, when they were taken, we still think they should have been used for campaign expenses after that point. If I buy Coca-Cola, is Home Depot going to use those monies for campaign purposes? John Oxendine PC, which he owns, is to make money for him. In multiple cases, between a campaign committee and a business owned by the candidate as the business as the candidate's personal assets. You did it in the Coomer case. Exact same allegation, even though there was no expenditure of money returned the same day, you made the same allegation. There was a 2010 case that was decided a few years ago where the allegation was made violated because a business owned by the candidate contributed too much to the candidate's campaign. You'd all dismiss that allegation, finding that the entity itself, owned by the candidate, was part of his personal assets, therefore it was not a violation. You made the same allegation after the preliminary hearing in 2019. You allege that the conversion of funds and the violation of 33A and 33C took place when the funds were transferred. Those transfers were in fact disclosed. The Commission's complaint in 2017 alleged that's when the clock started to run. And all of the arguments before the ALJ, your counsel argued that that's when the clock began to run.
When did Mr. Oxendine disclose these things that are on, the invested in Oxendine's PC were used for a deposit on Oxendine's personal residence, to cover shortfalls in his IOLTA account, purchase units in Kathmandu collections, right? When did the Oxendine campaign disclose these things?
Those transactions are what a lendee did with money, and
That wasn't my question.
I'm answering your question.
But you're not.
I am.
When did he disclose these things?
He didn't have to disclose these things on the disclosure report form. They were not disclosed by Mr. Oxendine. The disclosure report form lists, and the statutory requirement is you list the entity with whom the loan was made. The checks went from the campaign to John Oxendine PC. The disclosure report matches up with that. There's no guidance from the commission,
Okay.
no interpretation of the law, no form, no instruction manual on how you fill out the disclosure report that says not only do you disclose that transaction, you must disclose what the lendee did with the funds. Based on your theory, it's also irrelevant.
All right, so that suggests to me then, he didn't disclose these at all, and it wasn't until the bank records of July 18 where the commission staff learned about these transactions.
Actually, that's correct.
Okay.
Anything else? Are there any further deliberations? Does anyone have a motion that they wish to propose? I'll go ahead and make a motion. I make a motion in the Oxendine matter 2017-0169 PC. The OSA number is 2125875. I make a motion that we reject the decisions of the administrative law judge, specifically with regard to the expiration of the applicable statute of limitation. It sounds like the other issues have been conceded with regard to the other matters that were alleged, so that the only issues that do remain in the case are 33A and 33C. I think there were other issues that were addressed in the order under Section 34.
I believe the commission withdrew its argument on 34
Right.
as to the two violations related to the old disclosure reports, and the other provisions that they cited were definitional sections.
Right. In addition, with regard to that motion, to go ahead and get this case disposed of, I'm going to include in my motion that we not send the matter back to the Office of Administrative Law Judges, as Mr. Chalmers had suggested that we could do, and we will go ahead and get this matter scheduled for a final hearing before us sooner rather than later.
I'll second the motion.
We got it. Second, do we have any discussion on the motion? Hearing none, I will call the question. All in favor say aye.
Aye.
Any opposed? Hearing none, passes 5-0. I'll go ahead and tell the AG's office and commission staff to go ahead and work with Mr. Chalmers, of course, to go ahead at a mutually agreeable time to get this matter set down for a hearing.
Mr. Chairman, we respectfully request for the record a statement of reasons, reasons of law, findings of fact about why the commission has done this.
I'm not aware of there being any requirement in the law. It just says that we've got the, I'm looking at the regulations, it's just saying we can accept, reject, or modify the decision. We're rejecting the decision, as my motion stated, with regard to the statute of limitation grounds and the reasoning of the ALJ decision. We don't have to do that right now. No. You guys can coordinate that, and we'll run it past our schedule. That will conclude the review hearing with regard to 2017-0169. We do have another matter that we've got to address on the agenda for public comment. I don't believe, has anyone here signed up for public comment? No? Okay. That leads us to a matter of adjournment. Anybody got a motion?
So move.
Second.
Got a motion and a second. Any discussion? Hearing none, call the question. All in favor say aye.
Aye.
Aye. Any opposed? Thank you all.